Hi, I'm attorney Eric Lewis with Lewis Legal Services in Indianapolis. I have a very short video today about something that I hear and read all the time, and it's about what happens if you incur debt within a short period of time before you file a bankruptcy case. And this is something that's very confusing to a lot of people, including some lawyers, because I hear people say their lawyer told them it's okay to use credit cards for quote-unquote necessities. And the simple answer is no. It's not okay to use credit or incur debt that you know you don't intend to pay back. That's simple fraud. So why is there so much confusion? Well, the Bankruptcy Code tells us that among the debts you can't get rid of in bankruptcy is debt incurred due to fraud. And Code Section 523 tells us that you can't discharge debt incurred for money, property, services, or an extension, renewal, or refinancing of credit to the extent obtained by false pretenses, a false representation, or actual fraud. And later down in that same paragraph, it says, for purposes of the previous paragraph, consumer debts owed to a single creditor and aggregating more than $800 for luxury goods or services incurred by an individual debtor on or within 90 days before the order for relief under this title are presumed to be non-dischargeable. So that's where this idea of this 90-day rule comes in, that if you file bankruptcy and within 90 days you have incurred what they deem a luxury good or service, and it's over $800, that's where creditors could have a presumption built in that allows them to be able to seek having that debt excluded in the bankruptcy so that it's deemed non-dischargeable. It doesn't go away. So people, including some lawyers, have read this and think, oh, as long as it's not a luxury good or service and I can keep it under $800, then I'm good. And this is where the law and reality kind of take different paths. In reality, the truth is that many people do get away with this, even when the bank spots it, because unless the amount is rather large, the bank simply more often just doesn't want to get involved. They don't want to hire a lawyer and spend a lot of money chasing someone who likely doesn't have the money to be able to recover it from. And that's the reality of it. The law, on the other hand, simply provides that incurring these debts for luxury goods within the 90-day window creates a presumption in favor of the creditor. So presumptions in law are built in favor, they're basically built in to favor one side over the other. So for example, many people know that in criminal law, you know that defendants in America enjoy the presumption of innocence. This means that a criminal defendant can sit back and do nothing at trial, and it's up to the government to prove its case. In the context of a bankruptcy proceeding, if a creditor has a presumption in their favor, then it's much easier for them to win. But what gives people, or at least gets people into trouble, is they forget that just because there's no presumption, if they incur debt on things that they deem necessities, not luxury goods or services, that a creditor can't successfully prove its case. And if you rack up a lot of debt on the eve of bankruptcy, and let's say it's for groceries or clothing or something that might not be a luxury item, it doesn't mean that you're automatically safe from a creditor challenging the discharge of that debt. It just means that the creditor has more of an uphill burden in proving that you incurred the debt with the intent of not paying it back. And there are some fairly simple things that they can use. For example, they might be able to look at your bankruptcy paperwork and determine when you first hired your lawyer and see when you racked up the debts after that time. That could serve to show that you knew that you were filing bankruptcy and incurred that debt on purpose anyway. So yes, people do get away with it, but when you hear about the 90-day rule in bankruptcy and the difference between luxury goods and so-called necessities, just remember, it's a presumption built into the law. It's not an escape hatch to automatically get away with running up your credit card before filing bankruptcy and automatically getting away with it. All right, so that's it for today. Thanks for watching, as always, and if you like the content, subscribe, and again, we'll see you on the next video.